Good morning, everyone, and welcome to the session of the Tennessee Supreme Court here at Boys State. Our Scales Project, Supreme Court Advocating Legal Education for Students, brings together judges, attorneys, and students to help a better understanding of the judicial branch of government and the role of the courts in our society. Unlike cases you see on TV, today you will hear real cases with real lawyers representing real clients and real judges deciding these issues. We appreciate your participation, and we hope that you enjoy the case you will hear today. I want to thank Tennessee Tech University and Dr. Philip Oldham, President of the university, Jason Murphy, the Tennessee American Legion Boys State Chairman, Judge John Maddox, Vice Chairman, and all of you delegates and staff at this year's American Legion Boys State who have worked so hard to make this event possible. We would also like to thank the following law enforcement agencies who are assisting us with security for today's program: the Tennessee Highway Patrol, the Cookeville City Police, Putnam County Sheriff's Department, and the Tennessee Tech University Police, and also the Putnam County Emergency Medical Services. Thank you very much to all of you. Thank you as well to the attorneys who are arguing their cases today and for the extra effort and time required for the participation of you all. Some of you have had to travel a long way, and we appreciate that. We hope all of you students will stay engaged with the judicial branch after court today. You can follow us on Twitter at TN Courts, on our website, tncourts.gov, and on Facebook. The opinions we write on today's cases will be posted to our website and to our Twitter feed. Now I want to introduce you to the justices of the Tennessee Supreme Court. To my immediate right is Justice Sharon Lee, a past Chief Justice of this court. She is a graduate of the University of Tennessee with a degree in accounting and the University of Tennessee College of Law. Justice Lee practiced law in her hometown of Madisonville before being appointed to the Court of Appeals in 2004. She was the first woman to serve on the Eastern Section Court of Appeals. After serving on the Court of Appeals for 4 years, she was appointed to the Tennessee Supreme Court in 2008. Justice Lee is from Monroe County. To my immediate left is Justice Jeff Bivens. He is also a past Chief Justice of this court. He is a graduate of East Tennessee State University with a major in political science. He also graduated from Vanderbilt University School of Law. He practiced law in Nashville, served as an assistant commissioner and general counsel for the Tennessee Department of Personnel. He has served as a trial court judge and as a judge on the Court of Criminal Appeals. He has been a justice on this court since 2014. He lives in Franklin. Justice Holly Kirby is on my far right. She graduated from the University of Memphis with a degree in engineering and also from the University of Memphis Law School. She clerked for a federal appellate judge and then practiced law in Memphis. She was the first woman appointed to the Court of Appeals in Tennessee. She served on that court for 19 years before being appointed to the Supreme Court. Justice Kirby lives in Memphis. To my far left is Justice Sarah Campbell. She is a graduate of the University of Tennessee, where she studied political science, educational policy, and Spanish. After attending Duke University School of Law, she clerked for a federal Court of Appeals judge and a U.S. Supreme Court justice. She practiced law in Washington, D.C., and has served as an Associate Solicitor General and Special Assistant to the Tennessee Attorney General. Justice Campbell was confirmed as the court's newest justice earlier this year. She lives in Davidson County. I'm Chief Justice Roger Page. I graduated from the University of Tennessee College of Pharmacy and the University of Memphis College of Law. I practiced law for 14 years before being elected circuit judge in 1998. I was appointed to the Court of Criminal Appeals in 2011 and this court in 2016. I live in Chester County. As you can see, we're from different parts of Tennessee and went to different law schools. We all consider it a great privilege to serve on this highest court of Tennessee. We are committed to upholding the Constitution, protecting individual rights, and applying the laws of this state. We are now ready to go to work. Please pay close attention to this case this morning. Mr. Jim Hivner, who is our appellate court clerk, will now call our first case.
Ingram versus Dr. Michael Gallagher et al.
May it please the court, Art Brock from the law firm of Spears, Moore, Redmond, and Williams in Chattanooga, Tennessee, here on behalf of the appellant defendants, Erlanger Health System, which is doing business as Erlanger Health System, the Chattanooga-Hamilton County Hospital Authority, and also Dr. Gallagher. I'd like to reserve 5 minutes for rebuttal, if I may.
Yes, sir.
The issue before the court today is what is the effect of a voluntary non-suit of less than or fewer than all defendants in a lawsuit, and whether Rule 54.02 of the Tennessee Rules of Civil Procedure renders such a non-suit interlocutory and subject to revision at any time prior to the entry of a final judgment dismissing or dealing with all claims and all parties. We basically have 4 positions on these issues. The first is that a voluntary non-suit is effective when it occurs, and it has the consequence of placing the parties in the position they were prior to any lawsuit being filed and as if no lawsuit was filed. Second, that this effect maintains in all cases, including cases where the dismissal applies to fewer than all parties. And third, that Rule 54.02 of the Tennessee Rules of Civil Procedure does not change this consequence, does not change this effect, and essentially does not apply to Rule 41.01 voluntary non-suits. And finally, that a voluntary non-suit is not subject to undoing or un-non-suiting by a motion to rescind. I'd like to address the first point. A non-suit is an ancient right incorporated into a modern system based on rules issued by this court.
Mr. Brock, let me, what is the purpose of putting the order down after the non-suit?
Yeah, Your Honor, that's specifically addressed in Rule 41.013, and it is simply an order that is entered by the court to set the time frames for things to come. It's so the record is made, it's entered on the minutes, and it controls the running of things like the savings statute, like the statute of limitations. But it is, as this court has held, nothing but a pro forma ministerial order, which means that the trial court has no discretion in entering such an order.
But how is that totally true?
How is that?
Because how is that totally true? There are parameters on when a voluntary non-suit can be taken.
Yes, Your Honor.
And so the trial judge's function is to make sure there are some situations, certainly a number of situations, where the trial judge does not have the discretion not to enter an order, but it is his or her function to make sure that the requirements are met so that a voluntary non-suit can be taken.
Yes, Your Honor. Under Rule 41 and the case law, there are 6 circumstances under which the voluntary non-suit cannot be taken under 41.01.
So how is the language that you're referring to where it's simply ministerial? That's not entirely true, is it? Now, certainly some of our cases put in language that may be loose, might that fit that particular passage?
My response to your question, Your Honor, as I believe I understand it, what the trial court would do would determine whether any of these 6 circumstances exist. If they exist, the court would enter a different order. It would not enter the 41.013 order. If those circumstances...
Under those circumstances, the court can choose not to permit the non-suit, right?
The court cannot allow the non-suit under 5 of those. It has some discretion to allow the non-suit under the motion for summary judgment, under Stewart versus University of Tennessee. Mm-hmm. But the court has no discretion to deny the non-suit if none of those 6 circumstances exist.
Right.
So they would enter the order not allowing the non-suit under 41013, they would enter a different order. If those 6 circumstances do not exist, then it is a 41013 order, which is, as this court has held, purely pro forma ministerial order.
Under those circumstances, the judge's order is saying, I have reviewed the circumstances of this and the requirements for a Rule 41 voluntary non-suit are met.
Correct.
That's what the effect of the order is, right?
It is, Your Honor, and if none of those 6 apply, the trial court has no discretion but to allow the non-suit. The court has no authority to place conditions on it, has no authority to restrict it, deny it, or change it from without prejudice to with prejudice under the case law.
Mr. Brock, I mean, Rule 4101 is not the only way that a plaintiff can drop a party from a case.
It is
that
not,
right?
Your Honor.
So you've got Rule 21, you've got, you could do it by a Rule 15 amended complaint. To what extent does your position in this case turn on the voluntary non-suit? Would your position be the same if a party was dropped via amended complaint or via Rule 21?
It would not, Your Honor. I don't believe. If Rule 21 applied, those are misjoinders and non-joinders, but I don't, some states have held that's the method to approach. Georgia has held that's the way to approach these cases, but I don't think it should be a method around Rule 4101, because then it's a method around the restrictions imposed by the rule, which are you have 2 voluntary non-suits, or 3 depending on the circumstance, but there is a limit on how many times you can do that. So once under rule, either one, 15 or 21, the effect would be the same in the sense that the party is no longer in the lawsuit and no longer subject to a tolling of the statute of limitations, which is, of course, a major issue in this case. But there are other methods, and the fact is, in this case, the plaintiff filed his complaint on November 14, 2018. The plaintiff filed a notice of non-suit, actually an order of non-suit that constituted a notice on November 26, the same day he filed an amended complaint that dropped all those parties save Dr. Gallagher from the lawsuit. The next day is the day the order of non-suit was entered, the 27th. That's not been an issue briefed or addressed, but it does both have the effect, I believe, of removing Erlanger Health Systems from the case. They are no longer a party.
Do parties who are voluntarily dismissed from a case retain any involvement in the litigation, any kind of right to participate or opportunity to participate?
I think in large part that's what we're here to find out. But I don't believe so, and traditionally and practically they've not. When they've been non-suited, they have not continued to participate. They do, just as in this case, they do not receive pleadings by certificate of service. They don't get notices of deposition. They no longer participate, and it's our position is because they are effectively no longer in the case.
Doesn't this turn on, really, the language in 54.02 that says that any order or other form of decision is subject to revision at any time if it doesn't adjudicate? Doesn't your position really require us to add language to that rule? I mean, it might be that we get to the end of this case and we think, this needs to be considered by the Rules Commission to see whether the rule needs to be adjusted. But under the language that is currently there, I mean, it's plain as day. How is your position not adding words to that rule except a voluntary dismissal?
Because, Your Honor, it's our position that neither the purpose nor the text of Rule 5402 includes a voluntary non-suit.
Tell me what text specifically you are relying on. In
first instance, Your Honor, It's the court may direct the entry of a final judgment upon the certification required by the rule. A voluntary non-suit is not subject to being,
But we're not, that particular part of Rule 54.02 is not at issue here. Nobody made an attempt to do that, right? So in the second sentence of 54.02 subsection 1, what language are you relying on to support your position?
two, Your Honor, two primary textual provisions in 5402. One is that any other form of decision, a non-suit is not a decision by the Court of Appeals. A non-suit is a right of a party.
Well, it says the order or other form of decision.
That's true. My point is the court is not really taking any action on a non-suit. The court's not making a decision.
But you and I just talked about the fact that the trial judge has to enter an order finding specifically that the conditions for a voluntary dismissal are met.
I think it is the trial court's obligation to make sure that none of those 6 circumstances exist. But the court never enters an order making those findings. Just as in this case, the only order entered was the order of non-suit based upon Rule 41. There's no specific finding relating to those circumstances.
But it's still an order, correct, counsel? And the rules language in 54.02 says any order.
It is an order, Your Honor, but what the rule continues to say is an order or decision that adjudicates. A Rule 41.013 order does not adjudicate anything.
Don't you
non-suit.
think a dismissal of the claim would be an adjudication of the claim?
It's not an adjudication, Your Honor. We submit respectfully that the courts have held, this court in Himmelfarb and others, that the non-suit adjudicates nothing. An adjudication is a decision of rights and liabilities of the parties, and the non-suit and its order is specifically to avoid an adjudication. It is specifically to place those parties as they were prior to a lawsuit without any ruling on their rights, without any ruling on their liabilities. It is to undo the filing of the lawsuit. It's specifically under the definition of adjudication issued by this court, which has said that definition applies consistently with the rules. An adjudication is a decision affecting the rights and liabilities issued by the court.
If it's a dismissal with prejudice, wouldn't that would end that claim for that plaintiff against that defendant? Wouldn't that be an adjudication of the rights? And they could never be sued again on that claim?
It's not the order that has that effect. It's the statutes that no longer apply that make that effect. Again, the court is not deciding when it enters that order of non-suit. It's not deciding that the plaintiff's case is over, that there has been some effect. The court is simply letting the plaintiff take their right, absolute right, to undo the filing.
But how does this work with, for example, another type of dismissal without prejudice, where a trial judge dismisses a case without prejudice because administrative remedies were not exhausted? Or the trial judge goes back and says, oh, wait a minute, all the conditions for even a voluntary dismissal are not met. I allowed a voluntary dismissal when a summary judgment motion was pending, and I've now determined that was not the right thing to do. You're saying that none of that can be undone because it's not an adjudication on the merits? Do I understand your argument correctly?
No, Your Honor, I think any time the court is exercising its role as a court to decide an issue between parties, whether that be an evidentiary issue or a partial summary judgment or any issue in which the court is actually making a decision as a court, as between those parties, that is an order subject to Rule 5402. That's what it's saying. The court is making a decision that.
This doesn't say on the merits, does it? It's just an order on the claim.
Under 5402? Yes, that's correct, Your Honor. But it is an order that adjudicates rights and liabilities. It must be a decision that affects the rights and liabilities of a party, which again, the whole premise of the non-suit is to avoid that adjudication.
Mr. Brock, is this issue going to arise with us only when we're dealing with a governmental tort liability case?
No, Your Honor, I'd suggest it arises in almost all cases. This court has made decisions in Frazier, in Absher, that dealt with parties who were voluntarily non-suited, defendants voluntarily non-suited, less than all of them. And then how does a plaintiff rejoin those parties? In Absher, for example, this court held that 2 doctors who had been dismissed twice could no longer be sued. Even though there was a remaining defendant, the court has held those non-suits as non-suits were effective. They weren't interlocutory. They weren't somehow subject to being undone. They were effective. The same holds true in the Frazier case, where the hospital had been dismissed, but the suit continued against the doctor. So we are, again, no Rule 54 issue was raised in those cases.
Well, but isn't that the point, though? There was no Rule 54 issue raised in any of those cases, so there is no precedent under Tennessee law. This is clearly an issue of first impression, correct?
Yes, Your Honor, which is why we submitted the application for permission to appeal. We believe there was no specific case dealing with that.
To the extent that there appears to be some conflict between Rule 54.02 and Rule 41.01, couldn't that conflict be avoided? And I realize this has not generally happened in the past, but by having the trial court make an express determination that there's no just reason for delay when they enter the order on Rule 41.02.
Yes, Your Honor, that's a possibility, but what we would submit is that the history of the non-suit and its current status is that the court simply has no discretion to impose conditions on that non-suit.
But it could have discretion as to whether to enter it as a final order or not, couldn't it? It could make the express determination that there's no just reason for delay.
Not without altering the plaintiff's right to the non-suit. I mean,
you would still be granting the non-suit.
I saw that done when I was on the Court of Appeals, where a voluntary dismissal was made final. And did you request that that be done? Did anybody request that be done?
No, Your Honor. The non-suit was entered before any defendant had answered. So Erlanger never was a party, never was before the court.
But certainly could have asked the trial court, it may have been denied, but certainly could have asked the trial court to make it a final order.
I don't know if they have standing to do that. I mean, usually when you're non-suited, you're out of the case.
Certainly they would have standing to
They
do
had
that.
been served, correct?
I don't know that they had been served within those 12 days, Your Honor. I just don't know the answer
It
to
would
that.
require a separate, the order of dismissal would have been entered without really any participation by you, and then you would have to come along, filed a motion, gone through all that to get it entered as final. And that's not, I've never seen it done. It's rare. If it happens, it's rare, I guess, but.
Usually the defendant is just hoping the case doesn't come back like, whoa, voluntary dismissal, maybe they won't refile against us, and sitting back and being very quiet and hope that everybody forgets about them. But that's not the only option, is it?
Well, I think, again, Your Honor, under Rule 4101, the defendant has no role. I mean, the defendant is not able to petition the court to deny the non-suit, to condition the non-suit, again, assuming none of those 6 conditions apply.
It doesn't make it with prejudice, it just makes it final under the first sentence.
Under the purpose, as I understand 5402, Your Honor, is when it makes a final determination, it is, the purpose under 5401 is essentially to allow courts to make appealable issues that are not otherwise appealable. The non-suit is not appealable. It doesn't become final for the purposes of appeal. It doesn't become final for the purposes of res judicata, which under normal 5402, that's its purpose. It is to take something like a summary judgment of one party and say, we see no just reason for delay. We consider this a final judgment. Therefore, it's either appealed or it becomes res judicata.
Well, what if, for example, a summary judgment motion were pending, and the trial court decided, I'm going to let this plaintiff take a voluntary non-suit as to this party. There's an issue in that circumstance. And, I mean, clearly, the trial court then would have the option of making that final so that the defendant could say, I mean, the defendant may have been just on the cusp of getting summary judgment and getting dismissal with prejudice, and the trial judge permitted a voluntary non-suit. So, I mean, I have seen it made final and appealable under that type of circumstance.
And you could make it final without, I mean, it may be that in the majority of cases, a party would ask for that, that kind of certification for the purpose of taking an appeal. But I mean, that's not the only reason to seek that.
I don't know what other purpose it would have. I mean, the issue for the non-suit is, would it be appealable under any circumstances? In Justice Kirby's example, if the court is saying, there's a motion for summary judgment pending, but I'm going to allow your non-suit, the court is exercising its discretion. The plaintiff must show some reason to have that happen. That is not the normal Rule 41 non-suit. The plaintiff has to show nothing. The plaintiff takes the non-suit, the defendant is not aggrieved, and the cases have held that's not an appealable issue. So what would the certification be for an order that has, the defendant has no right to appeal?
Well, the certification would keep you from having to deal with Rule 54, wouldn't it?
Potentially.
Well, but you can refile within a year of that. The plaintiff can refile that suit within a year of that non-suit. So how could Rule 54 make it?
Well, that's,
You think that Rule 54, if you file the Rule 54 motion, would that be making it final? And so the plaintiff couldn't bring a second suit, do you think?
I don't see how under Rule 41, Your Honor, but
Yeah.
one of the problems is if this is interlocutory under 54 and 5402, and the defendant remains in the suit even though they are non-suited, is that the plaintiff then certainly is not able to bring a new action. We have now taken that out of Rule 41. There's no avenue for the plaintiff to bring a new action because that non-suit is not yet effective. So it has a dual edge to its effect, and the problem is, you know, in practice and even by statute and statutory history, the plaintiff has been able to take non-suits of fewer than all defendants.
Let me ask you this, Mr. Brock. So you cite a number of cases for the proposition that a voluntary non-suit kind of puts the parties in the position as if the action had never been filed, kind of rewinds the clock. Do any of those cases involve the situation we have here where you have multiple defendants and multiple claims, some of which proceed after the voluntary non-suit?
I think the cases that involve that, Your Honor, are Himmelfarb versus Elaine and the Frazier versus East Tennessee Baptist Hospital. But I don't think those cases, that those are cases where fewer than all have been dismissed, and in Frazier in particular, the court has said you may dismiss one, and the way to bring them back in is to commence a new action, and the Court of Appeals has interpreted that language as being the only way to rejoin a defendant. Another Court of Appeals has interpreted the rule as you have no jurisdiction over revising a non-suit after 30 days, and you must proceed by Rule 6002. So there is a split of what you do under those circumstances.
Thank you, Mr. Brock.
Thank you,
Time's
Judge.
up. You have 5 minutes in rebuttal.
May it please the court, Neil Thomas from the Hamilton County Bar, Chattanooga. With me is Michael Thomas, firm Thomas and Thomas.
I was certainly hoping you would acknowledge my former intern as your co-counsel.
If I didn't,
Thank you.
I'd be in trouble in more ways than one, Your Honor. Pursuant to Rule 5 of the instructions of this court, there is a case that neither of us has cited. I only ran across it preparing for this case. I'm not sure, based upon the colloquy between counsel and the court, whether it's still germane, but it is a case that was cited in the advisory comment only. It was not cited under Rule 54. I just happened to run across it, and it is the Green case. And pursuant to the instructions, we will submit a copy of that case to the clerk, but it is Smith versus Green, 101 Southwest 3rd, 415, decision by Justice Barker, in which he very clearly held that a notice or order of voluntary non-suit is not a final order for the purposes of appeal. The 30 days runs from the entry of a final order. The 30 days does not run from the entry of an order of entered on a voluntary non-suit. So I think it's pretty clear that, and I didn't have a case under Rule 41 until the Green case, but this court has issued 2 or 3 opinions that have said a grant of a motion for summary judgment is an order which may be modified at any time until the entry of the final order, and those cases are cases that we cited in our brief that Mr. Brock has dealt with as well. But the Green case was not cited, and I will send a copy of that through the clerk to the court.
Mr. Thomas, does this case turn on whether or not this court determines what adjudication means and whether or not a Rule 41 voluntary dismissal is an adjudication?
I don't think it does, Your Honor, because I think the rule at 54 itself is very plain. Says it only uses the word adjudication when it's for the purpose of certification, but it says any order, and it's very plain. It says any order is subject to revision before the entry of a final order.
Well, but you're missing that
Well,
adjectival clause that follows any order. So it's any order that adjudicates fewer than, let me get the exact language. So any order that adjudicates fewer than all the claims or the rights and liabilities, or fewer than all the parties. I mean, that clause modifies any order, does it not?
I'm not sure it does, Your Honor, because I think that goes to the issue of certification.
No, that's in that second part. That's in the second part of 5402. And I think this case really does turn on that. So I'd like you to address your interpretation of that language. And in particular, you know, we have said in Himmelfarb, we said this, I'm quoting, when a voluntary non-suit is taken, the rights of the parties are not adjudicated, and the parties are placed in their original positions prior to the filing of suit. So given that we have said that, and that we have this language in 5402 that talks about, you know, adjudicating the rights of parties, you know, how is it, so what should we make of that language in Himmelfarb? How do you get around that? 2
things, Your Honor. It said the Rule 54.021 says the order or other form of decision is subject to revision at any time before the entry of a judgment. Adjudicating modifies the word judgment, I would submit to the court. It's a judgment adjudicating all of the claims. That's for the purpose of finality certification.
No, I'm looking at the second part of 54021. So in the absence of such determination and direction, any order or other form of decision, however designated, that adjudicates fewer than all the claims or the rights and liabilities, or fewer than all the parties. So I'm talking about the clause beginning with that adjudicates fewer than all the claims and continues there. That modifies any order or other form of decision, does it not?
In the first part, yes, that's correct. I think, to be candid, I think the rule is confusing, first of all.
I agree with
I've
you
got to
on
concede
that.
that.
I think we get full, that's why we're here.
I know, and I think if to clarify, for the purposes of this case, if it had said, other than an order under Rule 41, it would have been clear as a bell.
I mean, this situation isn't ordinarily going to arise, is it? I mean, Chief Justice Page asked about that a little while ago. I mean, this case is unique in that it does arise under the GTLA. And so you've got this issue where, ordinarily the saving statute would permit someone who has taken a voluntary non-suit to, bring that within a year.
Correct.
So you're not ordinarily going to have this situation, which, may explain why it hasn't arisen previously, or at least hasn't come before this court previously. So, I guess let me ask it this way. Is it your position that under Rule 5402, when you have this situation where you have multiple claims, multiple parties, that any order other than one that is made final, expressly made final, under that first part of 5402 can be revised? In other words, there's no third category. There are either the orders that are made final, and then there's every other order, any of which can be revised at any time prior to final judgment. Is that your position?
It is, Your Honor, because I think given the vagaries of preparation for trial, any number of things, as in this case, any number of things can change the landscape of the case. So I think until that final order is entered, the trial court should be in a position to revise anything it's done based upon something that it discovers as a result of the proceedings in the trial court itself.
So is it your position that even
I'm sorry.
Oh, sorry, go ahead.
Unless 54 says, unless, or other than these particular types of orders.
So is it your position then that even the savings statute, the time limitation provided by the savings statute, which does apply to voluntary non-suit, would not be applicable in this multiple, multi-defendant context?
But I think the savings statute exception to Rule 41 addresses that issue. In other words, 41 says if you take a non-suit and that non-suit is not altered before the entry of a final judgment, it stays a non-suit, it stays an order of non-suit, then the savings statute starts running from the order of non-suit, not the final judgment.
And even in this context where you've got other claims, other parties, you
well,
would...
the savings statute would start, if the order of non-suit were not altered, then, and I guess that almost bolsters my argument that it is subject to alteration. If it's not altered by the time the final judgment is entered, the savings statute runs from the date of under Rule 41, runs from the date of the entry of the order of non-suit.
But let's say somebody takes a voluntary non-suit, court enters an order, 364 days later, they ask for a revision of that under Rule 5402. Is it your position that the court could grant that? And then they could...
I don't know. To be perfectly candid with the court, I'm not sure, because there you're also going to get into the motion was made on the 364th day, the order was entered on the 370th day. Are you outside the year or in the year because the motion was made, or is it when the order was entered? I don't know.
So I guess what I'm trying to nail down is it your position that the savings statute does not provide sort of a hard stop in this multiple defendant, multi-claim context when a voluntary non-suit is taken?
It does provide, Your Honor, for a hard stop if that voluntary non-suit order is not is still in effect at the time of the issuance of the final judgment. In other
But-
words, I'm sorry?
Well, so let me change up my question then a little bit. So if someone files, so let's say we're 400 days, we're 400 days past when the voluntary non-suit is taken, but there's no final judgment that has been entered in that litigation that has continued against other defendants. There's no final judgment there. Could the plaintiff who took the voluntary non-suit originally, 400 days later, so after the saving statute, could they come back in and ask for revision of that voluntary non-suit
Prior to the
order?
entry of the final judgment?
Yes.
I would have, because my gut tells me the answer should be no to that question.
What does your head tell you?
My head tells me duck the question, which I won't do.
I think with your
No,
argument,
but
you almost have to
I
say
think that
yes.
might get into another issue, and that is, wait a minute, what prejudice is going to result from the grant of this motion to vacate the voluntary?
Well, but that's a different question.
Yeah.
That goes to what standard would apply for when a court is, go ahead, sorry.
That's okay. No, I was just going to just kind of follow up on Justice Campbell's question, but to put it more in the context of the Governmental Tort Liability Act, the GTLA. As we know, the GTLA is the way in which our state has removed immunity from governmental entities under limited circumstances. And our case law tells us, though, that that removal of immunity is to be very strictly construed. If in the situations when the GTLA is involved, and of course, we also know that the saving statute does not apply when it's a GTLA case. In that situation, if we allow a party to come back under Rule 54 after the original time for filing a lawsuit against a governmental entity has occurred, isn't that an end run around the GTLA and sovereign immunity itself?
It could be, because the saving statute would not apply. In this case, that is another argument that we have that was not considered by the Court of Appeals, and that is the GTLA, the saving statute does apply in this case, because I'll raise another issue that has bothered me in this case, and that is GTLA says you got to bring the doctor in if you sue the doctor, and the doctor is an employee of the hospital. But then also GTLA and the case decisions say that the saving statute doesn't apply to the hospital and to be able to get the benefit of the year. But you would have the benefit of the year as to the doctor. So that's an unusual situation where you would have the benefit of the year, but the statute says you got to make the hospital a defendant, and the hospital can't be sued unless there's an exception to the GTLA waiver, which includes the saving statute, which is an argument that we made to the court, that to be able to reconcile the saving statute, then that would be a waiver of that protection to the governmental entity.
So is it your position that there would be a necessity of finding a waiver in this situation to support the claim that the saving statute did not apply and therefore would bar the lawsuit against Erlanger in this case? No,
Your Honor, because the saving statute would apply only if there had been a voluntary non-suit order undisturbed by a final judgment.
But again, isn't that in essence not strictly construing sovereign immunity?
No, I'm not even getting to sovereign immunity. I'm just sticking with the rule itself.
Well, but we can't ignore sovereign immunity here. Sovereign immunity is out there when a governmental entity is involved. And there has to be a specific removal of that immunity, and it has to fall within the guidelines of that removal of immunity, which is the GTLA and, in essence, the saving statute.
Right, but the GTLA saving statute doesn't start to run until there is a final order.
Do we get to that issue?
I don't think we do. That's what I tried to respond to Justice Bivens, and in that the first question to be answered is, does 54 apply regardless of what its impact may be later on? But here we have a suit that was brought originally against the hospital. There's no question about that. The original suit was timely. it was dismissed, and we simply seek a vacation of the order of dismissal as to the hospital which had been voluntarily dismissed, based upon circumstances which arose when the doctor said, you can't sue me without suing the hospital, and we said, all right, we'll bring the hospital back in. We're trying to get to the resolution of the dispute, and it's taken us a lot of procedural time to do that, but it's necessary. This is an unusual case. I will concede that to the court.
But the impact of ruling in your favor would be that, and again, if the rule says it, the rule says it, but in essence, a defendant who is non-suited from a case may still be theoretically on the hook for 10 years down the line. If it's a very complicated case, what about a mass tort suit somewhere, and that goes on for years and years and years? There's still the potential of that, under your interpretation, there's still the potential for that party being brought back in, is there not?
I don't think so, Your Honor, because that, I think, is a variation of what Justice Campbell asked, and that is if you get 400, 500 days out.
But I'm talking about before final judgment center. If that case goes on for 10 years.
Yeah, and I think that's why I was trying to nail
yeah.
you down on that, on what your position is on that, on the effect of the savings statute in that context. So when we're dealing with a case that doesn't involve the GTLA, because I think Justice Bivens may be right. I mean, depending on what your position is on this, because if your position is that before there's a final judgment in that pending litigation that goes on against other defendants, that the previous order of voluntary dismissal is subject to revision, and that litigation goes on for years and years down the road because it's very complex litigation, then I think that would be the result, right? That order could be revised 7 years from now, unless you want to take the position that the savings statute does apply. But I would need you to explain, how that's consistent with, your view of 5402.
Well, it does apply in the sense that if it's not disturbed, the action's barred.
But it may be disturbed 5 years down the road. I guess what concerns me about all this is if we rule for you in this case, a non-suited defendant's going to have to keep participating in the lawsuit until it's over.
That's what 41.0,
Unless the voluntary non-suit is made final,
Right.
correct.
which he has the option of asking the trial
That's
court to
correct.
do.
But which rarely happens, and if, assuming for a second, let's use 5 years as the number just to throw out, 5 years down the road, that defendant's brought back in, there's been, who knows how much litigation go on through depositions, through discovery, through motions, and everything else that now may have to be relitigated because that defendant's now been brought back in.
Unless you make part of that decision whether or not there has been prejudice to that defendant as a result of the passage of time before the motion to vacate the non-suit is made. That's the reason I think prejudice does come into this case. It's similar to amending your complaint. Will prejudice result from the amendment of the complaint if a party is brought in 2 years after the suit's been filed and is proceeded, but a new defendant is brought in pursuant to statute, within the time of the statute of limitations, the court can condition the grant of the motion under Rule 15 in that situation.
Well, to talk about prejudice for a second in this case, it isn't the fact that it would be essentially extending the statute of limitations under the GTLA, isn't that prejudice in and of itself?
No, because I don't think so, Your Honor, because until that voluntary dismissal is vacated, and if it's not disturbed, that defendant is out once you get to a final judgment.
But until you get to a final judgment, there is the lingering possibility that the defendant could be brought back in. Under your view.
That is a possibility, but I don't think that is within the factual confines of this case. This case involves a defendant, a governmental defendant that was originally sued timely, that was voluntarily non-suited and that was attempted with being brought back in within 3 months of the voluntary non-suit, which within 4 months of the commencement of the action. So this court does not have that situation where it's 5 years down the road and are we going to prejudice somebody. That's what the dissent.
But we could have, that case certainly could come along. I mean, what we decide in this case will of course affect
It could,
cases
but
like that come later.
yes.
So we have to be mindful of that as well.
Yes, I understand.
Can you, you've talked about prejudice. I do want to, I'd like you to be a little more precise about what standard you would propose that a court apply when ruling on a motion under Rule 5402, a motion to revise.
Has discovery taken place? Have dispositive motions been made? Why did the defendant, does the plaintiff seek to bring the defendant back in? I don't think the factors that have been enunciated in this court's decisions in the summary judgment case necessarily apply to this because that's newly discovered evidence, and I don't think you've got that here. But in other words, the prejudice could involve, which would be a situation for another case, has the 1 year of the saving statute run from the date of the voluntary non-suit. This may be the way to solve it. If the year has been, if the saving statute year has run from the date of the voluntary non-suit, and then say a year and a day later, that person says, "Oh, I want to bring that party back in," then at that point you can say, "Well, wait a minute. The statute already would have run if a final judgment had been entered, and now you're trying to bring me back in," and it does frustrate. In that sense, it does frustrate the.
Well, if it's appropriate for a court to consider that in ruling on a 5402 motion, then why would it not be appropriate for the court to say, well, in this GTLA case, the statute of limitations has already run, and ordinarily that the saving statute wouldn't apply? I mean, it's sort of the same analysis. You would just be looking at
it looks at it at a different point in time. I'll grant you that. It simply says the statute has run as to the governmental entity, and there is no saving statute which saves anything, and therefore that is the prejudice. But then it gets to the next argument, of course, that we made, and that is that there's been when the legislature says you must sue the governmental entity as well as the doctor, and that waives the non-applicability of the saving statute. But that was an argument that was not.
Has any court considered that argument?
What?
Has any court considered that argument? Has the Court of Appeals?
Not that I'm
considered
aware
that
of, Your
argument?
Honor. Not yet, because it's so new.
Let me kind of ask a different question for a moment. Let's assume for a second that we decide that Rule 54.02 should apply in this case, and that the non-suit was subject to being reversed and the party brought back in. Under a Rule 54 motion, the trial court has discretion as to whether to grant that or not, correct? Just like we're talking about prejudice and all that, correct? Trial court never had an opportunity to exercise its discretion under Rule 54 in this case, correct? Because it ruled Rule 54.02 did not apply.
Well, the trial court ruled under Rule 60, which the Court of Appeals says it should have been under 50.
That's my point,
right.
Is if in fact the standards are somewhat different under Rule 54.02, Rule 54 versus Rule 60, which I think case law does seem to indicate that, shouldn't the trial court be given an opportunity to exercise its discretion?
I suppose the answer has to be yes. Of course, the Court of Appeals answered that on its own.
I understand that. That's part of what I'm getting at.
I guess you would oppose sending it back to the trial court to make that determination, would you?
I wish you wouldn't do that.
Judge Pearson probably wishes we wouldn't too.
I mean, we've been at this for 3 years, and we haven't had the first lick of discovery in the case yet.
Judge Hollingsworth, sorry. Yeah.
So I think, I just want to check my notes just to make sure. I wanted to make sure that I said that Rule 54 does not exclude Rules 41, Rule 41. In other words, it said Rule 41 is not an order which can be considered under this rule, nor does Rule 41 say it may be considered under Rule 54. So it's both exclude. I think unless the court has further questions, that covers my argument.
Thank you, Mr. Thomas.
I appreciate it.
Hey, please, court. I would clarify for, I think it was Justice Bivens asked the question about whether the trial court exercised discretion under Rule 54 in this case, and the trial court did not. The trial court did find only that Rule 54 did not apply, and then applied the Rule 60 test. So no discretion was exercised, although I would note for the court that as of August, that judge will no longer be there.
That's true. He won't be. Well, that's right. He's retired.
Mr. Brock, we talked a moment ago, or during opposing counsel's colloquy about, the standard that would apply under 5402. I'd like to get your view on that as well. If we were to find that Rule 5402 applies here, is there a way to craft the standard there that would, allow for all of the competing interests that are at stake to be adequately considered?
The only one I can think of for the court is something in the lines of Harris v. Churn. Those are the standards that apply to revisiting a motion for summary judgment that's not final. And those are akin to things of new situations, new evidence, things not available at the time in order to take up the court's time, effort, judicial resources to reconsider something that's already been decided.
And what would your argument be about as to prejudice, how your client is prejudiced by being brought back into the case at this time?
Well, clearly Erlanger would have no prejudice as far as it goes to defending the allegations of the lawsuit because of the timing that was involved and those sorts. The only prejudice we would suggest is that we think upon a non-suit, we are no longer in the case, we are a stranger to the action, we are entitled to the effects of 41-1-2, which limits the number of times this can happen to a party so that when those rights are taken away, in other words, we think the non-suit vests us with some rights that are granted to us under 4101 and the protection of the GTLA, all of which are lost.
What is your response to the question as to whether a 41.1 dismissal or non-suit is an adjudication?
It is not an adjudication, Your Honor. Clearly, that's the law that this court has set forth, and it's under the definition of adjudication in other cases. It's under Himmelfarb. A non-suit by the court decides nothing, and it's our position that from the beginning.
Well, it doesn't decide the merits, but if you just look at Black's Law Dictionary on adjudication, it's just the legal process of resolving a dispute. I mean, it does. It doesn't resolve that on the merits, but generally, unless the defendant is, suit is refiled, then it resolves the dispute. There's nothing about it being on the merits.
It definitely has the effect of ending a lawsuit, certainly where there are no multiple party issues involved.
Right.
It certainly has the effect of ending the lawsuit, but it is because it's the non-reciprocal right of the plaintiff exercised to go backwards and not do that. In fact, it undoes all prior interlocutory rulings. None of those have any effect anymore.
All of that gets back to what Justice Campbell and Justice Bivens were talking about. Those could be factors that the trial court considers.
They could be. It's simply our position, Your Honor, that if the court holds that these voluntary non-suits are interlocutory orders subject to conditions and changes and being made final orders, that are still not appealable orders, but being made final orders, that the very essence and nature of the non-suit in this state has changed. Thank you, Your Honor.
Thank you. That completes the argument on our first case. Let me thank the attorneys again for coming over here from Chattanooga. I know it's not easy. We are arguing an East Tennessee case in Middle Tennessee. Let me thank everyone, all you gentlemen in here, for being on good behavior. This may be the most well-behaved group I've seen at Boys State, so thank you. We'll be in recess.